Now pleased to introduce Sir Geoffrey Nice. Sir Geoffrey Nice has been a barrister since 1971 and served as a part-time judge in England between 1984 and 2018. Between 1998 and 2006, he led the prosecution of Slobodan Milosevic, former president of Serbia, at the UN's International Criminal Tribunal for the former Yugoslavia. Since 2007, he has advised and represented at the International Criminal Court and elsewhere states, applicants, and victims concerning several internal and international armed conflicts. Sir Geoffrey was Gresham Professor of Law from 2012 to 2016. The floor is yours.
I will speak briefly about process, followed by Hamid Sabi, who will talk about the judgment, and with the chair's leave, we will then take some questions. The unlimited criminality and wickedness that man visits on man and woman in international, internal armed conflicts and in persecution of states by segments of their overall society, bringing about mass atrocities, are always associated, or nearly always, with another real wrong, done not just by the states involved in, say, the killing, but other states, by international organizations like the United Nations, and material for this particular matter, by professional bodies. And what is that wrong that they do? It is that they deprive those who have an interest of knowledge. They either lie directly about what has happened, or they decline for reasons of political convenience ever to acknowledge the truth of what has happened. It suits them. This has meant over recent years, by which I mean 70 years or 60 years, from time to time, just occasionally, there have been events where the truth has not been told and where it has been appropriate for things called people's tribunals to fill a gap in knowledge left intentionally or negligently by bodies that should have done the job. For those of you not familiar with people's tribunals, and there are many of them, the most famous in date order are probably the Comfort Women Tribunal that reported in 2000 into the sexual slavery of women in the service, as it were, of the Japanese military in World War II. That tribunal avoided the political niceties of General MacArthur and found the emperor himself responsible for the suffering of those unhappy women. Following that, there was the origin of people's tribunals, the Lord Russell Tribunal into Vietnam. No one was going to, and nobody ever has, assessed on an evidence base the general criminality of America in that war. The Russell Tribunal was deeply flawed in many ways, but it set a pattern. The Indonesian Tribunal looked at the massacre of communists in 1965, 1 million or so. Nobody was ever going to investigate that, partly because they were communists and because the West was involved in what happened to them. The 1985 massacre by the Ayatollahs of Iran of their opposition, in prisons in particular, was dealt with by another tribunal. Nobody's going to mess with Iran on such a limited matter as historical wickedness when there are so many other problems afoot. So they serve a potential purpose of filling an evidence gap, of filling a knowledge gap. And when I was perhaps I should just add this. Great if somebody could rewrite the 1948 Universal Declaration, but of course it wouldn't ever be possible nowadays, we know that, and add in one more right, the right to know. There's no state that would ever allow that right to be included. So sometimes it does fall for the ordinary citizen of the world to gather together and to answer a question that should be answered but has not been. And so when I was asked by the NGO ETAC, which commissioned the creation of this tribunal, to write a legal opinion on the matter, were crimes committed, I said, well, that'll be a waste of time. Nobody will read it. It'll never make it as an op-ed in a newspaper. It won't even merit a dusty file in a government office. But have you thought about a People's Tribunal? And they hadn't. And they didn't really think it was a very good idea at the time, because a People's Tribunal might challenge the certainties they already had. But they went away and they thought about it, and eventually they came back and they said yes. And so we created a model of a tribunal, different from the others, learning from them. Not based on lawyers. We didn't particularly want lawyers. We had a number on the tribunal, but they didn't work as lawyers. Not based on people with any commitment. 5 out of 7 members of the tribunal, I was one of them, knew absolutely nothing of this scandalous story when we started work on it. So we set up a tribunal of 7 people as it happened, and we worked on the basis that we would have evidence presented to us, which we did. Evidence would be given live and in person. We had 2 evidential hearings. After the first hearing, we converted ourselves a little bit into a tribunal of inquiry. We wanted more evidence. We asked questions so that we could fill in what we may have considered to be gaps in the information coming towards us. We applied only the most basic tenets of fair procedure, because that's all you require. Proof beyond reasonable doubt if we were to say anything adverse about the People's Republic of China, hearing live witnesses wherever we could, treating other forms of evidence with much greater caution, and not allowing expert witnesses to give final opinions on the very matters we were concerned with. That's about all you need for a reasonable determination of a difficult factual issue. And we then approached the evidence we got by putting it into silos or into little local universes of evidence concerning particular topics. There are a number of topics. Hamid, who will speak about these things, may tell you more. But we looked at topics of evidence, phone calls to hospitals, revealing what the hospitals were offering in the way of organs for sale, for example. And then we said, not what does this evidence tell us about the People's Republic of China. We said, supposing that evidence related to New Zealand, Canada, People's Republic of, not People's Republic, the Republic of Ireland, countries with good human rights record, what would that evidence prove to us to the level of certainty? And that way we insulated ourselves from prejudice. We built up a sequence of decisions of which we were certain, always operating at the highest common factor, or is it lowest common denominator, I never know which, among everybody, so that we were all certain of that which we agreed, put them together, and reached our result. And that's probably all I really need to tell you about the process. But it is a process that, on occasions, where issues are straightforward, and this is a straightforward issue, quite a lot of evidence, but it's a straightforward issue. This is a circumstance where citizens of the world, if they are disposed to give their time and effort, free of course, to simply answering a question, can serve, it seems to us, and I hope it will seem to you, a useful purpose. We have remained as a tribunal of 7, separate from the lobbying, the activist function. That's not for us. We are essentially like a jury in a criminal trial. We receive the evidence, we are told what the law is, and therefore how to reach our verdict. And once we've delivered our verdict, or our judgment in this case, we disappear into the shadows, and it is for those who are committed to acting in respect of this problem, them to do what they can and will with our judgment. And so it is that our judgment does show something to the level of certainty, proof beyond reasonable doubt, about the People's Republic of China. But also, it may be that it shows in a world where we are deprived of truth for all sorts of reasons by countries, international bodies, the citizen can sometimes fill the gap. Thank you.